Hello, everybody. I'm George from Ireland, and this is my trying to block out the light. This is my English law channel. So I'm going to talk more about public law and how the United Kingdom was formed in law. So not going to go into the constituent countries of the United Kingdom. It's a moot point whether the United Kingdom is one country or four or three and a quarter. But anyway, in the 1530s, Wales and England united, and Wales and England were represented in the same parliament. I shan't go back further than that. So the Wales Act was passed by the Parliament of England in 1536, admitting Wales to the same parliament. So anyway, 1707 was the Act of Union. England and Wales united with Scotland to form the United Kingdom of Great Britain. Anyway, and then the Scots Parliament, as well as the English and Welsh Parliament, passed that act. And then there was the Act of Union passed in Ireland, passed in Great Britain in 1800, creating the United Kingdom of Great Britain and Ireland from New Year's Day 1801. In 1921, the major portion of Ireland seceded from the United Kingdom. It's now the Republic of Ireland. So there's the United Kingdom of Great Britain and Northern Ireland. Great Britain, when used accurately, means England, Scotland and Wales. Northern Ireland is something else. But the UK includes Great Britain and Northern Ireland. Confusingly, in the Olympics, a team competes as Great Britain, but it also includes Northern Ireland. Anyway, so devolution has been going since the 90s. It means roll down in Latin. So things were rolled up, power was centralised at Westminster. That's a synecdoche for the Parliament of the United Kingdom, because that's the part of London it's in. Remember, the Parliament is sometimes called the Palace of Westminster because it was a royal palace and still is a royal palace in law, although no member of the royal family has lived there for centuries. So it's exempted from certain laws, for example, alcohol licensing laws. So devolution is a Westminster allowing other legislatures to have some authority, and Westminster not passing all the laws for the whole of the United Kingdom. Westminster controlling certain issues for the whole of the UK, but Wales, Scotland, Northern Ireland and indeed London doing their own thing on certain issues. But Westminster controls everything for England, beyond what local authorities control. So anyway, devolution is recognising the collective identity of people in Northern Ireland, Wales and Scotland. And so there can be different laws in different parts of the United Kingdom. So it's not quite a federal system of government. Now, in principle, Westminster could cancel devolution at any time, close down the Scottish Parliament, but it's really a political impossibility. So there are administrative, executive and legislative functions of devolution. The administrative functions, they're about transferring the power from central government in Westminster to departments in Scotland, Northern Ireland, Wales, and indeed London. Remember, there's a London Assembly, the directly elected Mayor of London, who's not the same as the Lord Mayor of London. The Lord Mayor of London is only for the City of London, the financial district, and that's an honorary position, the Lord Mayor, apolitical, whereas the Mayor is highly political. Right, there are executive functions. These are prerogative powers on behalf of Her Majesty's government. So the UK government is Her Majesty's government. So prerogative is both a right and a duty. So these ministers of these devolved governments can issue orders, or certain metro mayors, such as the Mayor of Manchester, Andy Burnham. The spat between him and the UK government over lockdown in Manchester, and the UK government prevailed because the law's on its side. It's unusual for the UK government to impose its will, but they felt it's so exigent that they were obliged to do so. There are legislative functions, the lawmaking powers, which have been passed from Westminster to the other legislatures in the United Kingdom. Remember, a legislature is a lawmaking body. For example, the Parliament of the UK, the Northern Ireland Assembly, the Welsh Assembly, so Welsh Parliament, as it has been from earlier this year, no longer Welsh Assembly. So there was a Royal Commission on the Constitution, known as the Kilbrandon Commission, after the man who chaired it in 1973. And it said that federalism was unsuitable for the United Kingdom, and the sovereignty of the United Kingdom was indivisible. It could not be divided. No granting independence to different parts of the UK. But it said, all right, there could be devolution to Scotland and Wales, where there's a considerable desire for it. Northern Ireland was a different matter. The troubles were on. Anyway, so in March 1979, referenda were held in Scotland and Wales on the same day, I think, and Wales by 75% rejected the idea of devolution. In Scotland, 52% of people voted for it, but the Callaghan government at the time said that at least 40% of registered voters had to vote for devolution for it to be implemented. Only 30%, 38% of those actually registered to vote voted yes, because you've got to remember some people didn't bother to vote at all. And so the Labour government said that wasn't sufficient and they weren't going to implement devolution in Scotland. So there's a certain asymmetry of devolution within the United Kingdom. Northern Ireland, Wales, Scotland and London all have it. England outside of London doesn't have it. I know they're metro mayors, but that's not quite the same as devolution. So Westminster controls the whole of the UK, but especially England. And the Prime Minister controls the whole of the United Kingdom, but especially England. So the logical thing would, shouldn't England have devolution as well? But England's about 55% of the United Kingdom's landmass and about 83% of the population. So a lot of people get confused and they conflate England and the United Kingdom. Anyway, in September 1997, there was a referendum in North Britain to ask people two questions. Firstly, do they wish a Scottish Parliament to be created? Second of all, do they want this Parliament to have tax varying powers, not just raising, they could make them lower than the rest of the UK. There was a high turnout and 74% did vote yes to the first question and 63% to the second question. So the Scotland Act was passed by Parliament the following year. Of course, the UK Parliament was not legally obliged to do so. And so the Scottish Executive was set up, subsequently been renamed the Scottish Government, and Scottish ministers, and there's the First Minister for Scotland. So the Scottish Parliament met in July 1999 for the first time since 1707 at the Mound in Edinburgh. It was the General Assembly Hall of the Church of Scotland, whilst its Parliament buildings were completed. The Scottish Parliament is now often known as Holyrood from its location within Edinburgh, across the street from Holyrood House Palace. So the Scottish Parliament could pass primary legislation, which it does, and there are certain reserved matters, as in the pound sterling, foreign affairs, defence, immigration, the monarchy, intelligence matters, but healthcare, schooling, criminal law, the environment, loads of social care, loads of other things, culture, the arts, is really up to the Scottish Parliament. And of course, Scotland is still represented in the UK Parliament. So those who are elected to the Scottish Parliament are called MSPs. Anyway, the Scotland Act of 2012 made additional changes to devolution, according to the recommendations of the Calman Commission. So there's a separate income tax rate in North Britain. There's another Scotland Act in 2016, and that gave effect to what the Smith Commission had suggested. Because remember, 2014, there was a referendum on separation for Scotland. The idea that Scotland would leave the United Kingdom altogether, be a totally separate country. But that was defeated. 55% of people voted no. So that Scotland Act in 2016, implementing Devo Max, it said that the Scottish Parliament government were permanent parts of the UK's constitution, and they couldn't be done away with without the consent of the people of Scotland. So it also said that the UK Parliament would only legislate for Scotland in relation to devolved matters when absolutely necessary. So it granted additional autonomy to the Scots Parliament. Furthermore, so it allowed the Scottish Parliament to change the Scotland Act 1998. It made Scotland more financially autonomous and so on in relation to VAT, and on and on. So anyway, Scotland was allowed to change things to do with road signs, speed limits, oil and gas, and so on, consumer rights. So then it allowed the Scottish Parliament to scrutinise various public bodies more. Previously, this had been within the purview of Westminster. So the Sewell Convention is also something worth knowing about. And this dates from 1998, when Lord Sewell, he was a minister in the House of Lords who put the Scotland Act through. He said that if Westminster legislated in a devolved area, as in an issue which was for the Scottish Parliament, it would not usually do so without the agreement of the Scottish Parliament. Anyway, So the Sewell Convention has now got statutory status as no longer a convention, according to the 2016 Scotland Act. Anyway, so there was a case when a Miss Miller, an anti-Brexit campaigner, she wanted to prevent the United Kingdom leaving the European Union. So there's a case called Miller and Secretary of State for Exiting the European Union 2017. It went to the United Kingdom Supreme Court. And she was suggesting that all the devolved legislatures would have to approve Brexit. But the Supreme Court said the Sewell Convention is not enforceable in the courts. So there we are. Seems almost worthless that the courts can't do that. So Miss Miller obviously didn't manage to prevent Brexit becoming a reality. So then there's a Scottish Continuity Bill, which you should know about, passed in 2018. The Scottish Parliament didn't agree to the European Union withdrawal bill. It wasn't required to do so. Remember, 62% of people in Scotland voted to stay in the European Union. Anyway, but nevertheless, the bill passed. So the Scottish Parliament came up with a UK withdrawal from the European Union bill, legal continuity. So the Attorney General and the Advocate General for Scotland said that leaving the EU or not was up to the Scottish Parliament. Well, it turned out not to be the case. So this is commonly called the Continuity Bill. So the courts can interpret laws, obviously in Scotland, the UK and Supreme Court can interpret them as well. So anyway, the Scottish Parliament asserted that as it has the democratic mandate to frame laws for Scotland, that therefore it ought to be able to determine whether Scotland is staying within the EU or not. But this is a contentious issue, and they didn't get their way on this one. So the Supreme Court was not persuaded by the Scottish Parliament's claim. Anyway, so because it's not within their competence, it's ultra vires for the Scottish Parliament to claim that. Anyway, so Scottish independence is a possibility. A lot of people, probably most people in Scotland at the moment, want to split up the United Kingdom. So that's probably enough about Scotland for the moment. Now we could look a little bit about devolution in Wales. So on the 18th of September 1997, a week after Scotland's referendum, Wales held a referendum on devolution, and there's only a 50% turnout. By the narrowest of margins, over 50% of people voted for it. So only about 25% of people in Wales actually voted for devolution, because remember, a lot of people didn't vote at all. So the National Assembly for Wales was set up in 1999, pursuant to the Government of Wales Act 1998. It subsequently renamed itself the Welsh Parliament. So anyway, the Welsh Assembly, as it initially had more limited powers, but they have increased. The Government of Wales Act 2006, they expanded the purview of the Welsh Assembly. And in 2014, there was the Wales Act, which put into effect the recommendations made by the Commission on Devolution of Wales, commonly known as the Silk Commission because of the person who chaired it. That's it really. So going on to devolution in Northern Ireland, obviously Northern Ireland had devolution from 1921, that July I think it was, right up until 1972. Various assemblies were brought back in Northern Ireland in the 70s, in the 80s, even the 90s, and they were really just talking shops, didn't have much legislative power. Well, in the early 70s they briefly did, only for a period of about 3 months, but we won't go into that. So the Northern Ireland Act 1998 granted devolution to Northern Ireland, and the Northern Ireland Assembly sits at Stormont, just outside Belfast. So the Northern Ireland Assembly is often known as Stormont for that reason. And so various powers are transferred to the Northern Ireland Assembly. And this is all related to the Good Friday Agreement, which is signed on Good Friday in 1998. So the Northern Ireland Act 1998 establishes 3 distinct areas of legislative competence. There are accepted matters, and these matters are never devolved, right, to do with defence, national security, nationality, the Crown. That's all for Westminster, in which, of course, Northern Ireland is represented. Then there are reserved matters, which might be devolved later on, but they're not devolved at the moment. For example, civil aviation. And then lastly, there are transferred matters, matters where the Assembly actually has competence to do with police, the environment, schooling, healthcare, the care of the elderly, the culture, the arts, language, and so on. So the legislation also requires there to be a cross-community administration. So some people in Northern Ireland are unionists. They wish Northern Ireland to remain in union with Great Britain. Some people are nationalists. They wish Northern Ireland to leave the UK and to fuse with the Republic of Ireland. So by law, the executive, that's like the cabinet, has to be partly unionist and partly nationalist. There's a first minister, who'll be from the larger community, whichever one that is. It's always been unionist so far, and a deputy first minister be from the nationalist community. So this power sharing agreement, this power sharing executive fell in 2017 over the language issue. Sinn Féin, the major nationalist party, wants more money and status for the Irish language, even though almost nobody in Northern Ireland speaks it. And the unionists said that's ludicrous, we're squandering money. More people can speak French in Northern Ireland than speak Irish. And the people who speak Irish in Northern Ireland are almost never mother tongue speakers thereof. Northern Ireland is lucky in having one language that everybody understands. That's not the case everywhere in the world. Anyway, so the Northern Ireland Assembly has been suspended. So the Secretary of State for Northern Ireland has had to take a lot of the matters back to Westminster. There's the Northern Ireland office as well. So they're trying to get things going. In January 2020, a New Decade, New Approach was published. And anyway, a new executive was brought back, including 5 political parties. There's been a campaign called English Votes for English Laws for quite some time. England is much more populous than all the other parts of the United Kingdom combined. So anyway, in 2015, the standing orders in the House of Commons changed things, and only those representing English constituencies could vote on matters which only affect English constituencies. That was according to what the Mackay Commission recommended in 2013. Of course, it's chaired by Mr. Mackay, hence it's got its names. So it's not about being English by ethnicity or birth or whatever, it's about where you represent. That's what makes you an English MP. So there are various issues touching intergovernmental relations. There's a joint ministerial committee which was established in 1999, just as devolution took effect. And this is to facilitate discussions between the United Kingdom central government and the devolved legislatures in Scotland, Northern Ireland and Wales on several issues. So there's a memorandum of understanding about this was published in 1999. That's not legally binding. And it said that certain issues which are not devolved, let's say Brexit, they have an effect on the devolved assemblies. And likewise, there's some devolved issues which impact the United Kingdom in its entirety. So the United Kingdom and the devolved assemblies, they agreed that they would try to discuss these things and make sure they weren't harming each other. So that's what the Joint Ministerial Committee is for, is to expedite discussions between the devolved assemblies and the UK government, and to try and negotiate if there's any dispute. And if they really can't agree, the Supreme Court will adjudicate what is the frontier between the competence of the United Kingdom government and that of the devolved assemblies. So there was a plenary session of the Joint Ministerial Council in 2018. And the Prime Minister, the First Ministers of Scotland and Wales, said they would continue reviewing this. There are also territorial secretaries of state. There's a Secretary of State for Northern Ireland, there's a Secretary of State for Scotland, and there's one for Wales. And they don't have to represent constituencies in those places. So there we are. That's just a brief overview of the history of devolution in the United Kingdom. So thank you for watching. Please donate on PayPal. See my major channel, Tortram Ireland. Toodaloo.